Strike Patterson has applied remarked strike as a boil on the body and is indicator and symbol of industrial unrest. Following are the conditions which are required. Following are the conditions which are required to be fulfilled before going on strike in breach of contract of service in public utility service. Number A, person employed in a public utility service cannot go on strike without giving a notice of strike within 6 weeks. That means he must give a notice of strike within 6 weeks before striking. Such a notice is not necessary when already a lockout is in existence. When already there is a lockout, then notice of strike is not necessary. When there is already a lockout, then notice of strike is not necessary. But person employed cannot go strike without giving a notice of strike within 6 weeks before striking. Before striking within 6 weeks, he has to give notice of strike. But whenever lockout is in operation, then notice is not required. If lockout is in operation, then notice of strike is not essential, is not necessary. Notice may be given by union or representative of the workmen elected to do so. Who will give the notice? Notice may be given by union. By union. Notice of strike can be given by union or workman elected to or representative of the workman elected to do so. A notice of strike will not be effective after 6 weeks from the date it is given. From the date it is given, a notice of strike will not be effective after 6 months. From the date it is given. Like today I have given the strike. Then a notice after 6 weeks from today will not be effective. So the strike must be effected within that period. If strike is not made within the period of 6 weeks, after expiry of this specified period, fresh notice has to be given. That means I have given the notice now, and after 6 weeks, within the period of 6 weeks, no strike has been conducted. Then after expiry of 6 weeks, I have to give a fresh notice of strike, because that notice period, the period of notice of strike shall be expired. A person employed in public utility service shall not go on strike within 14 days of giving such notice. Such the strike can take place only within the last 4 weeks. No person as employed shall go on strike before expiry of the date of strike specified in the notice. No person so employed shall go on strike during the pendency of any conciliation proceeding before a conciliation officer. It may commence only after 7 days of its condition. Strike as defined in clause 7 of section 2 of the act means cessation of work by a body of person employed in any industry, or concerted refusal, or a refusal under common understanding of any number of persons who use or have been so employed to continue to work or to accept employment. At least there must be 2 persons for strike. As per the definition, concerted refusal can be between 2 persons only. The length or duration of period of strike is not important. What is important is the refusal or cessation of work, that too without giving notice to the employer. The limit is a must. Ram Swarup versus Rex AIR all to the 204, explaining the essential elements of strike. The Supreme Court has held in Northbrook Jute Company Limited versus its workman AIR 1960 SC 879 that refusal to do the work which employee is not bound to do is not strike. Joint action, refusal is necessary element. Cause of strike: a demand for reconsidering the issue of retrenchment, expulsion, or suspension. Demand for reconsidering the issue of retrenchment, expulsion, or suspension. Lockout. According to Section 22, Clause 2 of the Act, no employer carrying on any public utility service shall lock out any of his workmen without giving them notice of lockout within 6 weeks before locking. Within 6 weeks before locking. The date of locking, before the date of locking, within this period of 6 weeks, the lockout notice must be furnished. Number 2, within 14 days of giving such notice. Number C, before expiry of the date of lockout specified in such notice as aforesaid. Number D, during the pendency of any conciliation proceeding before a conciliation officer and 7 days after the conciliation conclusion of such proceeding. The term lockout has been defined in section 2 clause 1 to mean the closing of a place of employment. Lockout means closing of the place of employment or suspension of work or refusal by an employer to continue to employ any number of persons employed by him. No doubt the strike and lockout are the two sides of the same coin. A judgment in this effect is given in Sri Ramchand Spinning Mills vs. State of Madras, AIR 1956, Madras 241. It was held in this case that there are two weapons in the hands of employee and employers respectively. It's aimed to bring pressure on the other party to concede the demands. Lockout is a counter of strike. Karvela State, Kotagiri versus Rajmani. There are three essential elements of a lockout. Number 1, there must be closure, suspension of work, or a refusal to employ. Number 2, there must be the consequence of an industrial dispute or in anticipation of an industrial dispute. And number 3, it must be intended to compel the employee to accept certain terms or conditions of employment. Notice from the above, it follows that in case of a strike, the workman, or in case of a lockout, the employee must give a notice of the same before 14 days from the date of the strike or lockout. The case of the strike, the workman, and in case of lockout, the employee must give a notice of the same before 14 days from the date of strike or lockout, as the case may be, and after 6 weeks before the date of the strike or lockout. The notice of strike or lockout shall not be necessary when there is already in existence of a strike, as the case may be lockout in public utility service, or as the case may be lockout in the public utility service, but employer shall send intimation of such lockout or strike on the day of which it is declared to authority as may be specified by appropriate government, either generally or for a particular area or for a particular class of public utility services. Rule 71 of the Industrial Dispute Central Rules 1957 requires that the notice shall be in Form L. The notice of strike in case of strike shall be given by such number of persons to such person or persons or in such manner as may be prescribed. The notice of lockout in the case of lockout shall be given in such manner as may be prescribed. On any day an employer receives from any person employed by him any notice of strike or gives to any person employed by him any notice of lockout, he shall within 5 days thereof report to the appropriate government or to authority as the government may prescribe the manner of such notice. The leading case on the subject is Buckingham and Carnatic Company Limited and versus Worker of Buckingham and Carnatic Company Limited, AIR 1953 SC 47. The facts of the case were as follows. On 1 November 1948, the worker of Buckingham and Carnatic Company Limited demanded holiday in the afternoon due to a solar eclipse on that day. The management did not accede to the demand. This led to the stoppage of work by a section of night shift workmen from 5 pm to 10 pm. The management treated it to be illegal strike. It took the form of an industrial dispute and was referred to the Industrial Tribunal, Madras, for adjudication. The tribunal held the strike to be illegal as the textile industry was notified as public utility service, as the work was stopped without any notice required under Section 22 of the Act. Both the parties went in appeal against the judgment of tribunal to the Labour Appellate Tribunal, which upheld the contention of the management. A Labour Appellate Tribunal also held that the stoppage of work was not a strike and thus did not constitute a break in service. The punishment was set aside. The management filed the appeal in the Supreme Court. Time factor, it is duration of a strike is not very important. Duration of the strike is not very important. It may be even for a few minutes or hours, provided that it may be even for a few minutes or hours, provided that other ingredients are present. Stay strike is not proper. To be present at the place of work and still doing no work is treated as an offense of trespass and grave misconduct. To be present at a place of work and still doing no work is treated as an offense of trespass and grave misconduct. This is ruled in Sara Musa Sugar Works Private Limited versus Sarabati Khan AIR 1960 SC 160. Right of strike is not a fundamental right. Right of strike is not a fundamental right. This principle is held in Kameshwar Singh versus State of Bihar AIR 1962 SC 1166. Strike and staging dharna or procession is no doubt a right but not fundamental right, as is ruled in B.R. Singh versus Union of India 1989. Strike versus lockout. The Supreme Court held that it was clear from the fact on record that the workers were acting in concert in suspending the work. All the necessary ingredients of the definition of strike under section 2 clause 9 were present to constitute the stoppage of work. A strike through it was for a few hours only. It was not a case of an individual worker's failure to turn up for work. It was concerted action on the part of a large number of workers. It was illegal strike, having been declared without prior notice required to section 22 of the Act. In Crompton Grips versus the Workmen AIR 1978, Supreme Court 1489, it was held that a workman is entitled to wages to the period of strike only when the strike is legal and justified. Likewise, it has been laid in Spencer and Company Limited versus Workmen 1966 that if striking workmen are dismissed from service, they can claim reinstatement only if it was established that the strike was the result of unfair labor practice on the part of the employer. So that's all about this lecture. If you find it useful, like and subscribe my YouTube channel.